Hey, chat is to the whole audience? I thought chat is only to organizers.
You see the little thing at the bottom? It says you can switch to organizers and panelists only.
I haven't used this one. I usually use GOAT, the other version of this. So I thought the chat was on.
Hey,
I'm launching
Hey,
now.
Andrew, listen. Hey, Andrew, can you stop the recording and restart it so it's clean at the beginning?
The broadcast is now starting. All attendees are in listen-only mode.
Welcome to today's webinar, Till Death Do Us Part, Understanding the Prenup Process. This webinar is scheduled for 1 hour, and so before we begin, I'd like to review the control panel, which is the rectangular object located on the upper right-hand side of your screen. The orange button will minimize or maximize the panel, and if you don't see the panel or lose the slides at any time, you can click the blue flower located at the bottom of your screen. During the program, you can chat questions to us. So if you click on the plus symbol next to questions, that opens up the chat box there. So feel free to ask questions during the program or at the end. And so let's take a look at the next slide. We have an upcoming family forum and pre-forum workshop in early March on successfully managing transitions and change in family enterprises. So family members will share their experiences and explore change and transition topics like hiring a non-family CEO, innovation through generational transitions, selling the legacy business, and the process of reinvention. And so Andrew Kite, one of my co-presenters today, he'll speak about maintaining family unity during transition. The great thing is that we're staying at a gorgeous hotel called La Valencia on the coast in downtown La Jolla. And so we have a really great social event planned for all the attendees as well. So if you're interested in attending, registration ends tomorrow, and so please register today. So with that, let's open with the SBN code. We open all of our webinars and live events with this code. It's part of what makes SBN so special. So the network was founded on the principles of trust and openness. And so please participate by actively listening and asking questions. We respect confidentiality, each other, and act with a high level of professionalism. Of course, we are a non-solicitation environment free from sponsors and advisors. So on the next slide, we'll get started today. We're going to talk about prenuptial agreements, who needs them, what are the benefits and drawbacks, and how do we create a valid agreement, and how do we have the conversation. So we'll talk about those things and other things as we dig into this topic. So I'd like to introduce my co-presenters. We have Andrew Kite. Andrew's the clinical professor of family business, the Family Business Center at Loyola's Family Business Center, and he's also the president of SBN North America. We have Domingo Sook. He is a partner at Perkins Coie. He serves as the co-chair of the Family Office Service Practice, and he is general counsel for his family business and family office clients. So welcome to the both of you.
Thanks. Glad to be here.
All right, so just for some level setting, we'll start off with the definition of a prenuptial agreement. So it's a contract that's executed prior to marriage. If it happens after marriage, then it's a postnuptial agreement. But basically, it's a written agreement that describes how property and assets will be divided in the event of a divorce and how assets will be handled upon the death of a spouse. And so prenups are becoming more and more popular with people who want to protect assets and those of modest means as well. And so here are some reasons on the next slide. So asset protection, of course, and it can be also used to protect spouses from each other's debt. So if you already know that your fiance is a spender and in debt, you know, you might choose to consider a prenup to protect you in the event of a divorce, and you won't have to assume that obligation. So for a couple who has children from a previous marriage, you might want to use a prenup to pass property to all of your children. Some people want to clarify their rights and responsibilities financial responsibilities during marriage. So this is a good method to do that. And then another reason for prenup is if you need to take care of other people, like elderly parents or family members that have that are physically or mentally challenged in some way. So on the next slide, then, we will look at some benefits. Actually, we won't look at some benefits.
So I'll jump in here. And so we're going to talk about both prenups and a couple of other mechanisms to protect assets, because I think when we think about prenups, we think primarily about that as the tool, while there are other tools to protect the assets that we're talking about. So when we're passing assets down, we're talking about passing property, wealth, and or a business in a family business. So to achieve our goal of family business succession, we're talking about protecting the ownership and protecting the value of that ownership for future generations so that we can maintain control and continue to live the family values through our organization. So we're not just passing down the property, wealth, or the business, we're also passing down the family legacy. We're trying to build family unity and continuity across generations. So having a prenuptial agreement policy in our family business can be an effective tool to stage for that transition. So we are protecting the ownership in our family businesses. So there are kind of three mechanisms we're going to talk about. We're going to talk about prenups, but we're also going to talk about other ways that we can protect some assets outside of prenups. So when we think about buy-sell agreements, this is one of the first ways that we protect ownership in a family business. So having a buy-sell agreement, which is also sometimes called a shareholder agreement, sets the stage for the rules of ownership in our family companies. Who can own shares? How can we sell shares? How do we value shares? All of these things are typically outlined in our shareholder policy. So this is the first, I guess you could call it the first line of defense when we're talking about protecting the ownership of our family company. So if our intent is to keep the stock in the bloodline, you can do that in your buy-sell agreement first. Now that, of course, has limitations, which we'll talk about. But the benefits of the buy-sell is that it can make the valuation of the stock very clear to all parties. And obviously this is a double-edged sword because you're talking about the challenge of estate planning as well. So once we set the value of a stock, the stock has estate tax implications. But when we're clear about what the value of the stock is, it helps us have conversations and plan for the future. The buy-sell can establish the goodwill component of a value. It can prohibit transfers of stock to non-family members, including spouses. So this again is one way that we can protect the ownership of the company. And it can provide for the provisions to buy out a family shareholder if they leave the business or they just want to sell their shares and create liquidity. So this is one of the first mechanisms where we can start to manage the ownership of the business. The limitations are that the buy-sell agreement is up to interpretation by the IRS, and that it may or may not respect the buy-sell agreement. Domingo, do you want to jump in and just offer your thoughts on kind of what are the limitations from a legal perspective on enforcing a buy-sell agreement?
Sure. I think one of the points to raise, and I'll start from the bottom bullet, the IRS may or may not respect the buy-sell agreement. What we're referring to here is actually valuation of shares of stock, which can be contractually binding, but in 1990 the IRS changed the rules for valuing stock. So in other words, there was going to be a disconnect going forward that if the IRS did not like or agree that the buy-sell mechanism that is in a buy-sell agreement is equivalent to what is defined under the Internal Revenue Code as fair market value, the IRS was able to get the law changed so that you can have that disconnect that Party A and Party B would be contractually obligated to exchange shares at a set value pursuant to a buy-sell agreement, but the IRS could value that same share of stock at a different price. So that obviously leads into the first bullet, which is there has been significant disputes about what is the value of stock, and to try and eliminate that, you want to have a valid buy-sell agreement, but we need to make sure that it is in conformance with the current tax law rules, which have been evolving. And for those who have been tracking this, I know there was a lot of chatter in the end of the year from August 2nd when the IRS announced their proposed regulation for the value of closely held businesses, all the way until most recently the Trump administration putting a hold on the issuance of all regulations. So the tax implication is significant. We're going to talk more about the contractual aspects and the legal aspects for where buy-sell agreements are limited, but these are the two main highlights: valuation tying into the IRS, and then when there is a dispute, of course, the dispute, if it escalates enough, it's going to end up in a court-styled situation, and then we're going to be looking at state law to determine what is the value of shares.
So, for instance, I've seen in a number of families in their buy-sell agreement, they have book value as the valuation of the stock. How would that typically be looked at by the IRS?
That would be frowned upon. That was one of the provisions that the IRS was saying when there's a contractual obligation to transfer shares at book value, which was very common prior to 1990, that the IRS was not going to be obligated to respect the value of those types of transfers, because the transfer at a book value, which could be historic at a 1955 price, would not reflect the fair market value of that stock today, although that might be what the buy-sell agreement did. And that's why we're very sensitive as practitioners. If you have a buy-sell agreement, we have to pay first attention to when was the buy-sell agreement adopted. Post-1990, it has the new IRS rules. Pre-1990 are what we call grandfathered provisions.
Got it. Got it. Great. Well, we'll come back to that valuation question because it plays into account when we talk about prenups in themselves. Another way that we protect our assets in a family business is through trusts. So again, the prenup is not your only tool to manage the transfer of stock and keeping stock in the family in the event of a divorce. And I'm sure Domingo will tell you that trust is probably one of the strongest mechanisms for inheritors of wealth. And so, Domingo, do you want to make a few comments about why trusts are such a strong mechanism for inheritors of wealth for protecting assets?
Sure. And I think, Andrew, you're drawing the exact line for the point that I would like to make, that an inheritor of wealth is in a very different position than a creator of wealth. I think that as we're talking about prenups, for certainly somebody who is creating wealth during a marriage, then having the prenuptial agreement is going to allow them to define the rights, as Jennifer mentioned in the beginning, and what is the division of property and what happens with that property during marriage. As Andrew is pointing out, when we're taking the multi-generational approach to family business assets in particular and the legacy that's planning, now I'm going to take a perspective of a parent transferring assets or planning for a child. Even though that child is going to get married, how can you pass assets to that child in a way that might afford creditor protection in a way that the child cannot do for themselves? And the common vehicle for estate planning is to use a will combined with a trust, and to have a trust be in place for beneficiaries, such as family member, next generation shareholders in that family business. The shares of stock could be placed into a trust, and the trust would be a more effective mechanism to keep the stock outside of the marital estate of the husband and wife or partner, as opposed to doing a prenuptial agreement where the assets came into the direct ownership of that child. So as Andrew's pointing out, the purpose of a trust will be looking from the perspective of probably the more senior generation passing assets to the next generation.
Great. So, I show that can really be a benefit in that you can provide the protection without, in some ways, having the conversation. So those assets get protected before you even get into the conversation of a relationship situation. You can't force the trustee to make a distribution from the trust because the trust has its own rules for how assets can be dispersed from a trust. Have you ever seen, Domingo, a spouse try to challenge the disbursements, and how does that happen in a divorce setting? Do spouses try to get access to those disbursements?
Probably the seminal case in this area comes out of this great state of Connecticut, where a couple were getting divorced, and one of the spouses said that a division of marital property should also include a trust for which the other spouse was going to be receiving distributions. The court actually looked at that and said, normally we would not take that into account. However, given how intertwined this family's affairs had been, and because the trust provided for a direct outright distribution to that beneficiary in a few years, it was short enough in time that the court said it was foreseeable, and indeed found that they were already looking, the couple were looking towards those distributions, that a portion of the future distribution, so the distribution wasn't even coming out yet, it was just going to come out in the future, would be divided between the marital estate. So that was a very far departure. They tried to make it akin to retirement assets, which are retirement assets that, of course, that a couple would, the working couple would put assets in a retirement plan, and it's very common to have retirement assets split between spouses because it's assets that are accumulated during a marriage. But this was remarkable in the sense that this is assets that were set aside by somebody else for the benefit of one of the members of this couple. And but for that outright distribution, which now, it wasn't that the court, and this is how the court got around it, the court wasn't forcing the trustee to make a distribution. The court said it's foreseeable that the trustee was going to make this distribution because the trust agreement said at a date certain a distribution was going to be made, and then because the couple acted in reliance of that, they were able to, if you would say, you could consider that either piercing the trust or at least looking enough that a spouse, a creditor of one of the spouses was able to access assets.
So in general, though, is that more the exception to the rule than the rule?
That is absolutely the exception to the rule, which is why I was building the facts of the caveat upon caveat. But for a court looking at it, but for an outright distribution of the trust assets, but for the couple relying on those future projections of distributions to them to, I think it was financing a house or financing something, but for all of those things, the general rule is, as you said, a trust provides the benefit of creditor protection, and a trustee should not be forced by a court to make any distributions.
Got it. So let's talk, can you talk a little bit more about the limitations of trusts then, Domingo?
Sure. So the other side of that is there are certain things now that are public policy concerns, and I think the common phrase for the first bullet that we have in this slide is a deadbeat parent. And you can have a deadbeat parent in the sense that a parent who is not paying their obligations to support their own child, you will be allowed to, a court would be allowed to pierce a trust for the benefit of the child for which the parent has been providing their support obligations. So that's one of the ones that's just out there, that if you're not providing for the support of your child, you're obligated to, and so they don't look at that as quote-unquote piercing the trust. The other one is a trust established after the marriage, particularly if it's done in anticipation of a divorce, may be and will be, is probably just as easy to say, scrutinized by a court. So in other words, timing here matters. If there are circumstances why people are trying to, you would call it defraud, hide assets, or move things away from the spouse, those are all going to be frowned upon. But if you do this up front, just like we're talking about when you negotiate a prenuptial agreement, that is going to be looked favorably, and if you do follow those rules, you'll get the benefits of a trust, which means that a spouse would not be able to access that. You would get full creditor protection unless you're a deadbeat parent.
So that's completely separate of, let's say my parents were putting something in a trust for me during a marriage. That's at the discretion of my parents. That's not me, so that would not be under scrutiny.
Correct.
This is just if I were putting some of my assets in a trust during a marriage.
Correct.
Got it. All right. Great. So Jennifer, why don't you take us into the prenups conversation?
All right, great. So we're going to return back to the prenup conversation and look at some benefits and drawbacks using a prenup. It requires full disclosure of assets, which could be a benefit or a drawback, depending on the person and situation. But it really provides a space for talking about finances, about your respective views on things like the purpose of money, spending, saving, giving, investing. It gives space to talk about and create some financial goals. And so the conversation can actually support and strengthen the relationship before marriage. And so this discussion too, is never easy, but it can reduce tension between the couple who's getting married and also with a larger family. It provides more control and privacy and power if the couple decides to get divorced, because they get to decide on how the assets are divided. And let's see, the other thing I want to mention is that some families make prenups mandatory, and when you're part of a wealthy family or business-owning family, moving forward with a prenup can actually be a sign of stewardship, responsibility, and maturity, that you have a larger sense of obligation to the family versus yourself. Anything you'd like to add there, Andrew?
No. Well, I would say that when you look at the conversations that couples have, I think financial conversations are often one of the most difficult conversations for a couple to have. So the prenup can set up before a marriage some initial conversations about how are we going to manage money, and we'll talk a little bit more about managing money after a prenup, because that's a very important piece of the enforceability of the prenup as well. But I'll talk about a few other benefits, which is that a well-drafted prenuptial agreement is routinely held up in court. So when we talk about the provisions of a successful prenup and the process of a successful prenup, we know that they'll be upheld in court. We can clarify the rights and expectations in the marriage and reduce the expense and stress in case of a divorce, because we know how things are going to be split up, and we won't hopefully end up in long-standing lawsuits around a divorce.
So some drawbacks. So it's not romantic. I doubt that people are having this conversation today since it's Valentine's Day.
Oh.
And it's it's hard for people to talk about what might happen if we get a divorce. When you're excited about the future and planning a wedding, this is a difficult conversation to sort of interject there. And so another major drawback, which I mentioned a little earlier, is the possibility of creating friction in the relationship and friction with the rest of the family. So marriage presents a unique challenge to families in business and families of wealth who are confronted with the prospect of sharing their lives and legacies with individuals who come from different backgrounds, who have little knowledge about the family dynamics, responsibilities that come with owning substantial assets. And so on the flip side, with potential married-in family members, they come with their own family identity, their values, their conflict style, and may view the conversation as a sign of distrust and might feel mistreated by the language and sort of actions by the person who is broaching this subject. And so we'll talk a little bit more later on some tips for having the conversation. Andrew, anything you would add there?
Well, I would just share a story. You know, one of the families that I worked with, this was a family of 3 brothers, and the oldest brother was getting married, and literally about 4 weeks before the wedding, Dad comes to the oldest son and says, well, here's the prenup you have to get your wife to sign. And so this individual was marrying a woman who came from a family where her father was a Marine, and obviously there's a lot of stress building up 4 weeks before a wedding, and now we're throwing a prenup conversation into the deal. And so obviously the potential spouse of the fiance was pretty worked up. Her father got involved and created a lot of tension leading into the wedding that probably didn't need to be there. And the interesting thing was the father always had this intention that there was going to be a prenup, but he never talked about it with his sons. So the good news for the second and third sons was they now knew that there was a prenup expectation, but it was certainly an example of a process that didn't go very well and ended up creating a lot of tension, not just between the marrying couple, but also between the families, because there was a significant amount of education that needed to happen between the spouse, the couple getting married, you know, so that the spouse can understand what is this all about and how to engage with it. So the process is just as important as the details behind the prenup. So there's some limitations to a prenup agreement as well. You know, Jennifer alluded to some of these things, that it can be difficult to raise and resolve differences and come to an agreement in this situation. If we don't draft a prenuptial agreement in a sound way, it can be challenged in court. And when prenups are put forth in a pressure situation, such as the example that I just mentioned, it can be alleged that the prenuptial agreement was entered into under duress and can be open to challenge. Domingo, can you say more about that duress clause and how it gets changed?
Sure. So let's take 2 examples, and you've highlighted one. I'm going to assume that the hypothetical that you have there with the 3 brothers, that brothers 2 and 3 have exactly the same terms for their prenup, but one gets their prenup done before they even get engaged, and the other one has it done, as you've alluded to in the example, 4 weeks before the wedding. Same exact terms. The question is, should they be enforced equally? And that duress component, which is why it merited its own separate bullet item in this limitation of a prenup, is the conventional thinking is you can have the same exact terms, but the timing of when you do it can change everything. So sometimes we know we have that nice phrase that says timing is everything. In this case, it's not necessarily the timing, but it's the timing that causes duress that can change a perfectly valid prenup with one brother into an invalid prenup with the other brother, using your example. So that's one aspect. The other aspect is the poorly drafted prenup, which will be subject to court challenge, are typically prenups that are just unclear, ambiguous, or show sloppiness in the terms of how they were put together or manhandled, if you will, because they don't just fit. As Jennifer noted, this is not the romantic part of the wedding. but it is certainly an aspect that I think should be dealt with. Is you've mentioned, Andrew, the process of getting married, and when you're in a family that has significant assets or finances, however you want to be looking at it, a family business, legacy, etc. Some people do these just with respect to their family legacy, their name. Confidentiality agreements are very common now with prenups, that one of the things that we haven't highlighted here in particular. But those arrangements now are getting to be more commonplace, because if you don't have a prenuptial agreement that addresses it, the flip side is going to apply. Things that are not prohibited in the prenup, we're going to consider as fair game. So ambiguity, the ability to deal with issues that we have seen before with families are all the points about why you're raising this, that there are limitations with the prenup, there's timing, and there's clarity in the drafting so that all the parties who are working together can have, actually, I would say, a more blissful marital life, as opposed to one that just gets off to a rocky start because the process didn't commence properly.
So, what I hear you saying is that a prenup can be as broad or as narrow as we like. So you could have a prenup that just pertained to the family business ownership. But you're also saying that anything that's important that we want to protect should be written out in the prenup, because otherwise it's fair game.
Sure. Yeah, that's exactly right. Another simple way that I've commonly used in counseling clients on this as we get to know them, and I'm going to make this presumption that they've talked about certain aspects of the marriage, and now they've talked to me how they've met, they've talked to me about how they've commingled or not commingled their finances up to date, and so I typically will start with a premise. Can we start with an assumption, or is this an erroneous assumption to say, what's yours is yours and what's mine is mine? And if you get both sides just starting from that, you will find out whether or not we're in for a difficult ride, or if we're in for, okay, well, we have an overarching premise that we respect about, being yours is yours, mine's mine. Now, I recognize that there's lots of obligations that are still under the law, and that's what we'll have to do as you go by each particular principle. But, I think as we're sitting here on Valentine's Day, the question is, have you been going Dutch on your dinners and celebrations or not?
So what are the, a little bit about how we would create a valid prenup agreement, Domingo?
Sure. This is actually fairly straightforward, but we do need to highlight this because we have seen these mistakes. And in the context of family businesses in particular, I think we want to make sure that we avoid these mistakes, because a mistake in this context could be detrimental to the family business assets. So the first point that we have here is that each party must have its own independent legal counsel. So in this case, we'll be referring to commonly lawyers, and that each party to the marriage, the fiancés, will have their own counsel to review the prenuptial agreement, understand the negotiation for the back and forth, and then actually enter into an agreement which we would say would be entered into freely without duress by each of the parties. Now, if that premise is just respected, what then ends up happening is we have 50 states. Each of the states has their own particular state laws. And so there is what we call a state law uniform premarital agreement act, from which all states have commonly adopted their own premarital agreement act. So actually this is an area of the law that has already been statutorily defined. What we're trying to do is get compliance with the law. And of course the default is, if you don't have a prenuptial agreement, which is why this is going to be prudent, we haven't emphasized this point, if you don't have a prenuptial agreement, and you think that you can just reach an agreement at the end of the marriage, assuming that there is a dissolution of this marriage, which only 50% of marriages end in divorce. That's the common law statistic, so take your chances there. If you don't want to have the prenuptial agreement negotiated up front, what you're really saying is, we're willing to negotiate as parties in front of a judge, because frankly that is what's going to happen. We have talked about enforcing prenup agreements in terms of a court. Well, what happens if you don't have a prenup agreement? Well, then you're leaving yourselves at the mercy of the court to negotiate in front of the court about how these provisions will be, and bad acts by either spouse during this period of time is what's going to be the most influential on the court. So a couple quick points just on that. If you think about the concept that it is prudent and wise for all of us to have a will, especially once you have children, so that you can designate guardians. Why do you do that? Because a guardian is no more than the parents selecting who should take care of the child if the parents are unable to do so. Well, what happens when a parent doesn't have a will? What have we done? If you don't comply with the statute that says a will is going to allow you to designate your guardian, what have you just resolved yourself to do as the default? You have resolved that a court is the one who's going to be able to arbitrate for you to select who should be the guardian for your child. That's just the default. We need to understand and look at it in that light, as opposed to this is an unromantic thing. The unromantic thing is actually your failure to address the prenuptial agreement is actually a default saying we're going to let whichever judge happens to be sitting in divorce court that time, should we ever get divorced, is the one that's going to be the arbitrator for us, because we can't have this conversation through this process. So if you go through the process properly, you conform with the marital act, premarital act, and you have your own independent counsel, the only thing that the court would look at in terms of validity is it fair at that time? So there is always a sense of equity in this, that the court would take oversight over an agreement to make sure that it wasn't inequitable when it was entered into. Absent that, compliance with the law, independent counsel for the parties, there will be prenuptial agreements enforced between multimillionaires and spouses who are nowhere ever going to get millions of dollars from that situation. And I'm just commenting on that because that was deemed to be fair by judges when they went into a prenuptial agreement. Contrast that to the situation where there is no prenuptial agreement and now you're going to have to split up marital assets. You are definitely going to have a different split as opposed to what might have been in the prenuptial agreement, and that's why it's very important to know that perspective. Where are we coming from? Are we starting from what's yours is yours and what's mine is mine? Are we a marriage of equal financial means between couples, which is being referred to in the common press as the marriage of peers, financial peers, as opposed to one being more endowed than the other? All those situations come into play and will help determine validity of the prenuptial agreement.
I've never heard somebody refer to, do you want to leave it to the situation of the judge that you end up in front of, because that really is the way. And I actually was just talking to somebody who was from a small town, and her husband was a police officer and knew the judges in the town, and so when the divorce ended up in front of the judges, she felt like the judges were favorable to her husband because he knew them through the legal system. So I think that's an interesting piece. Now you referenced the Uniform Premarital Agreement Act. You want to talk a little bit more about that?
Sure. So there are a couple of criteria that the Pre-Marital Agreement Act specifically points out, which is just like with most contracts, we want to make sure that this agreement is in writing, signed by both parties, and you get that attestation with the independent representation of your counsel. Typically the lawyers in that case will also be attesting to that they negotiated on behalf of each of the parties in the agreement. That gets to the point that we say here it's voluntary. That's what the lawyers are meant to counsel on, to have both parties enter into the agreement voluntarily, so that it is exactly what we recite there in the last bullet, which was the overarching point that we raised already, that is fair. And how do they determine fairness? Now the Act gives us the specificity that there should be financial disclosures of financial obligations of each party, and then they can either waive, i.e. they're satisfied that seeing statements, all the statements from the retirement accounts, ownership in the family business, and the like is fair, that the other side did not hide the ball. Remember, I was saying before, if you are fair, then the court will institute it, but the court will review the contract for fairness and the fairness is going to be deemed by the disclosure of the parties. So if you do have a billionaire marrying somebody who is not a millionaire, and the disclosure of that person is not tantamount to being reasonable disclosure of their financial wherewithal, then the parties entered into that agreement without adequate opportunity to negotiate, and that's where premarital agreements would fail to be valid. So the Act simply has these points about agreements in writing, voluntary, and now fair and reasonable. And if we go to the next slide, we'll see that there's a couple more permissible provisions in the prenuptial agreement. It is primarily what are going to be our obligations with respect to property rights. And this means that you can exclude property rights. So as I was suggesting before, there are situations, and I've seen this more in the marriage of, call them financial equals. What's yours is yours and what's mine is mine. This now gets to the point that, you know what, whatever you earn from your retirement savings, your employment, that's yours. Whatever I own is mine. We'll have a pot. The pot is the commingled pot for common household expenses, other investments, etc. That's what would be divided if we were ever to divide anything, but everything else is going to be kept separate. And that has happened through contracts in other situations that I have certainly counseled on. What we then look at are provisions about what happens when there's a death, a divorce, or other defining event, very similar to an estate plan, that when there's a change in life circumstances, should certain things happen. In prenuptial agreements, they are dealing with these particular provisions of death, divorce, or some other event which can be defined in the agreement. And then you can either eliminate or pare down spousal support. I think people refer to this more commonly as alimony, and alimony has certainly gotten a bad rap. Lots of other states have adopted the point that we don't have alimony. And then even jurisdictionally, here in the great state of Illinois, Illinois is a common law state. Wisconsin, right up north, is a community property state. It is well known that there have been high-profile cases where rather than get divorced in the state of Illinois, one of the spouses might file for divorce in Wisconsin because it's more amenable to a 50-50 split of marital assets when you're in a community property state as opposed to a common law state. So there's always angling that's going on if we're in a particular state or a particular jurisdiction. And if you have property in that state, i.e. if your second home, as is common for some wealthy Illinois clients to have a lake house up north in Wisconsin, that's how this sometimes happens, that the divorce happens in Wisconsin as opposed to Illinois. And that ties into the point that or the last bullet that's being raised there of common law versus community property states.
So
with that, go ahead.
So let's say if we're in Wisconsin, and is a prenup still valid then in Wisconsin, even though it's a community property state?
Yes, but the question is going to be, did the prenup, assume it's entered into in Illinois, which is a common law state, did it address, and this is a tough one because this is where the ambiguity comes in, not every practitioner addresses this. It's a valid prenup for Illinois purposes, but it didn't contemplate if a divorce proceeding is filed in a community property state, or worse yet, the couple moves to a community property state, which then arguably in that state would trump the prenuptial agreement. So there's lots of follow-on provisions that this is not a contract that we're married on Valentine's Day, we entered into the contract, we never have to think about it again. I think that somebody once quoted that if there is a marriage contract, what we need to understand, like the Constitution, it should be more viewed as a living document which needs occasionally amendment, but certainly can be a living document that contemplates future changes in circumstance so that we don't get boxed in. So,
we have a national audience here. Are there a lot of community property states around the country?
There's, I believe, 12. So.
Great. So what is permissible in a prenup agreement?
Sure. Permissible provisions, and this is continuing the points that we raised. You can have the point about attorney's fees. So this is not all too uncommon, but this gets to the point again about fairness. If you have a wealthy spouse with a less wealthy, or actually you'd say the fiancés, one of them is less wealthy than the other, there can be provisions for the payment of the negotiation of the prenup, which would include financial advisors. So you'd have a financial planner sometimes that does projections for people. Certainly the CPA chimes in, as well as the attorney that's drafting. In the event that there is a divorce, one of the common provisions to negotiate, whether you're on either side of this, you should be expecting it. If you're on the wealthier spouse, then you want to make sure that for the other spouse to be fair, we're not just going to bury them in expense that they can't afford to fight the divorce battle. I think we've all seen some of the more recent high-profile divorces where there's a New York lawyer, there's another lawyer that comes in from a litigator, and then they pick a jurisdiction where they're filing in, and it's all of these high-profile cases that this was so-and-so's lawyer in the Rupert Murdoch case, which was the most expensive divorce on record. It could be the Jack Welch case. There's all these high-profile points, and what I'm raising here with the attorney's fees or other costs is that the less wealthy spouse would actually get representation to be able to match the other spouse's legal team, because it's not going to be a fair fight when you have a heavyweight contender against a lightweight. So that's one of the provisions. Provision for reimbursement and offset of support and the attorney's fees and costs pending the final judgment. This is getting to now that period, right? There is a case that I had to work on, and it was a divorce that, if you can imagine, I know people think that we're going to go get divorced, we're going to go down to the courthouse. We got married in an hour, especially if you went to Las Vegas. How long can it take to get divorced? Well, some people say, you start a divorce proceeding, it can be 1 year. Some people talk about it, well, you're not taking into account the period where you have to be separated from each other under some of the dissolution acts. So there's that cooling off period before we want to let people get divorced, so they're actually legally separated, term that's used out there. So you're separated for a period of time, and then all of a sudden, now you're more than a year out. Well, the longest divorce case that I have worked on spanned over 12 years. So that'll give some people perspective that when there's a lot of money at stake, these fights can go on and on and on.
Wow, that's a long time. So maybe we should talk a little bit about what you can't put in a prenup.
Sure. That's a great topic to have, because there are certain provisions, and these are just easy to tick off. I like this. No metal in the microwave. So what we cannot put into the microwave here is actually the right of a child, or limiting the right of a child to support. That is an absolute no-no. So the court, as we've talked about some things, is going to be the final arbiter of certain things no matter what. So a marriage between two consenting adults, fine. We can define what the rights are. But the rights of a minor child are always going to be paramount. That's why we see the deadbeat parent exception to accessing assets. We also see here that a child's welfare is going to be viewed as paramount over the parents' issues, whatever they're fighting over at the time, and that includes that custody and expenses for the child cannot be addressed in a prenuptial agreement. Other things that also come up commonly are things that are against public policy, which, as we know, public policy has been shifting, and so some of those shifts have been with respect to just what is a marriage, and does a marriage have to be between a heterosexual couple or not.
Got it. So how do people typically challenge prenups, and how does that play out?
Excellent question. So as we look at this particular slide, we see that prenups may be challenged if the party claims that it was unconscionable or executed under duress. And notice the capitalized and underlined word "and." In other words, this is conjunctive. There's two elements of this. So let's go back to this first part of the phrase. May be challenged if a party claims the agreement was unconscionable or executed under duress. I touched on the point about duress before, duress typically referring to not enough time under stress. Unconscionable is the legal term for fairness in the court opinions. The courts don't just say that we found this unfair and so we decide X. Typically, the courts will refer to the legal term of unconscionable because it just says beyond fairness. This is just bothering the court's conscience. It's bothering courts of equity, so that's why they're using it as unconscionable. So you have those elements, and the party must not have received fair and reasonable disclosure of the other party's assets. And then there's one more conjunctive, but before we get there, let's talk about this. Fair and reasonable disclosure is what we talked about earlier. Fair and reasonable disclosure of finances. How is that going to be determined? It's going to be saying what was the material that was provided when this was discussed? Did the other party have an opportunity to ask questions, probe into it, or did you just give them saying, I'm worth $1 million or $1 billion for that matter? So if you have one element here about unconscionable and under duress, and there's not fair or reasonable disclosure of the assets, and now here's an interesting one because this is where the lawyers can be either good advocates or not, you can actually waive the disclosure requirement. So now we're going to be asking in this process, did you waive the disclosure requirement or not? So how are you represented on this? And this is now where people think about it. You know, lots of papers flying around. You need to know what you're signing, and this is why people have said you shouldn't sign anything unless you understand what the agreements are. Typically, prenups can be certainly less than 50 pages. Maybe they're 20 to 30 pages. And then there's the signature pages. We'll have the waivers pretty clearly within there. Those should always be read, and then if there are questions asked of their lawyer. And then here's what the court determines. Did not or reasonably could not have had. Who's that? The complaining spouse did not or reasonably could not have had adequate knowledge of the other party's finances. So all of that leads up to the court getting to the point that we are not going to uphold the prenup as being valid. If you miss any one of those four prongs, i.e. there's a waiver, or there was reasonable disclosure, or you did actually abide by everything in the statute such that there is no duress and it wasn't unconscionable, then the court is going to uphold the benefits of prenuptial agreements.
Mm-hmm. Got it. So this slide really talks about the limits of eliminating spousal support. Can you say a little bit more about this?
Sure. So the point on this is the alimony, and that the court can disregard the alimony if there is going to be a hardship on that spouse that was not foreseeable at the time of execution. So what is this really contemplating? Think of the situation where you have a prenup and you have modestly wealthy people, and let's say they were a meeting of equals. So they were just going with the what's yours is yours and what's mine is mine. But then you get one of these, let's go back to the Silicon Valley tech era, where you have these newly minted billionaires with the emerging technology from technology, but one spouse is the one who benefits from that, the other spouse did not. But after 30 years or 20 years, however long they're married, and then we assume that they get divorced after that long period of time, they've gotten used to an accustomed standard of living, but their prenuptial agreement was never updated, and it simply provided for alimony of X amount of dollars for the periods of time tied to the length of period that they were married, but it doesn't take into account that now, if I was just going to keep the residence, there's no way that I could support this lifestyle that I'm in. That, in that particular circumstance, for that particular spouse, should be negotiated, and a court would not hold them reasonably bound to that provision when there's been such a life-changing circumstance.
All right. You know, we've been through a lot of the pros and cons, the challenges. Let's talk about, like, once we've made the prenup agreement, what are the important things we need to do to administer that prenup?
So depending on what the situation was, how they negotiated from the what's yours is yours and what's mine is mine, we're going to come here with a couple of principles. You do not commingle separate assets with marital assets. So there's always going to be an exception for certain assets that were either inherited or that were never commingled. So in other words, if I owned this watch before I got married, and it just so happens that this is an antique watch that's museum quality, is my spouse entitled to a quote-unquote a piece of that when we get divorced? You would argue that that was separate property that was never commingled. Well, a watch may not be easily commingled, but a bank account, I'm going to close out all my personal bank accounts, and I'm going to just have us have a convenience account, which will be our household account. Now all of our money has been segregated. And if your prenuptial agreement was reciting that we were going to keep things separate, but then as a practical matter you thought it would be easier to just get one bank account because you were tired of having so many different bank accounts, now you've just violated your own prenuptial agreement. And that's why sometimes it just makes sense to have those reviewed as you're planning things or you're making financial changes as you go forward. The result of that type of commingling is the second bullet point there, which is the waiver of abandonment of those protections. So you said we were going to keep things separate. What's yours is yours and what's mine is mine. We don't commingle things, but lo and behold, you found that they commingled. Now all of a sudden the court has something to latch onto that you didn't violate, or you didn't respect the prenuptial agreement, and it can violate it. I know we're going to get close here to the time, but let me just tell you one story. I have a situation where the clients actually did keep everything separate. They did have a household account. The spouses were supposed to deposit their salaries into the household account, which they did do. The child, who is getting separate gifts from their parents, got a deposit, and instead of depositing it into what is historically their separate account, they deposited the money into the joint account for the household, so the commingled account. Based off of that one deposit, almost 6 months worth of proceedings and evidentiary findings had to be found because now you violated your own terms. That's how the care and maintenance, to the extent that you're either sloppy or you pay attention to the details, could come back to rear its head or save you, depending on which side of this issue you were negotiating.
All right. A couple more slides, and then we've got some questions coming in that I want to get to. So for those who have to jump off at 1, we'll try to get through these last couple of slides and then jump into question and answer. So I want to talk a little bit about managing the relationship through the process. So one of the things, based on the story that I shared earlier, that having a policy can do is it can set the expectation, because as I've worked with families over the years, the biggest consternation that usually comes up about prenup agreements is the process, and that we didn't expect it was coming, that we haven't had the conversation in a timely manner, and it becomes about the two individuals rather than what it's really about is protecting our family business legacy and the greater good of the whole family rather than merely focusing on the couple themselves. It too often gets interpreted as you don't trust me in the relationship. And so having a policy as a family and the expectation that everybody in the family participates can mitigate that piece of it's just about these two people. So in order to do that, we really need to educate our family members and start at an early age. So if I've grown up since the age of 14 knowing that prenups are a part of the equation, and the people that I've dated know that as we get more serious, that when we get to the actual engagement, you know, the intensity of that process is reduced. So talk about it early, at least 6 months out. You know, 12 months or further out is advisable because you have plenty of time to work through the issues. You want to communicate the purpose that this isn't about the two individuals, that it's a broader conversation about the family business and what it means to the family and perpetuating the family business and the family assets. Wherever possible, pick a neutral location when you're having these conversations. And don't necessarily have a draft at the first conversation, because that really implies that we've already put together the agreement. We just want you to sign it, so you're not really going to have any input in the conversation. So if we can just start the conversation with what is the purpose of this prenup, why do we have this policy in our family, and talk about the policies itself, that can start the conversation as well. And one thing you might consider is sitting down and listening to this webinar. We have a recording of this webinar. You can sit down and listen to that with your potential spouse and kind of just understand at a very neutral level what are prenups about and why do we have them. And sometimes, again, meeting with the fiancé's parents can be important too, so they understand the situation and that we can communicate that we're really talking about creating a fair agreement between two parties. So I'm happy to take any questions now, and I'll start with one that came in while we were talking, which was, at what age is the best time to set up a trust for your kids? Domingo?
I'll take that one. So what age is the best time, or what age is the best time to set up a trust for your kids? So there are two types of trusts that we've been talking about. There are revocable trusts, which do not have a irrevocable component because they're revocable for the parents. And then there are these outside trusts, which are irrevocable trusts, typically known as gift trusts. Sometimes they're irrevocable life insurance trusts. Sometimes they're grandchildren's trusts. All flavors come up. But you cannot create a trust for the benefit of someone until they are in existence. So right now, if you don't have children, it's very difficult to say that you want to set up a trust for your children. A trust has to have a current beneficiary. As soon as a child is born, and we have this for some families, as soon as a child is born, minors, what we call minors exclusion trusts, are created, and they get funded immediately by various family members. So you can start having trusts for children as early as their birth date. Grandparents set up grandchildren's trusts commonly, and they use the parents as current beneficiaries to get around the rule that you can't have a trust for grandchildren until the grandchildren are born. But there's lots of ways to go about it. The question is, tell me what the circumstances, and we can talk about the proper trust vehicle that would fit that circumstance.
So basically, you can start a trust and put ownership into it as soon as a child is born.
Yep.
Great. Another question that came in that Domingo, you might reflect on is, with all the changes in provisions around marriage and gay couples, how have you seen families deal with same-sex couples and marriage, and how does that, in states where marriage isn't legal, how does that play out in same-sex couples?
Well, let me throw out two circumstances because I think it'll cover most of that panoply. If you have a state that has recognized marriage between a heterosexual couple as equivalent to for a homosexual couple, then you are actually just dealing with a prenuptial agreement for a homosexual couple the same way that you would deal with it with a heterosexual couple. So there's not a big difference there. There's other nuances, a lot of them tax-driven around that. But where you have situations where there's still policies or issues about having the validity of the marriage, or you have other situations where couples have gotten together over a period of time and they just wanted to get into what they called committed relationship, domestic partner relationships, and in some states like Florida you can actually file to have a domestic partner relationship with someone. It's an interesting thing because now you have to take the inventory. Do you want to actually get married? Are you happy with a domestic partner relationship? And the reason why you have to counsel on those is, you know what, sometimes people like the domestic partner relationship better because then you don't have to go through all the rigmarole of an actual formal divorce proceeding. You can actually terminate a domestic partner relationship just like you would a lease contract, as opposed to here where you have property rights pursuant to a marriage because you expect it to be united as one under the law. So lots of nuances that are more specific to cover in that circumstance depending on state jurisdiction.
Gotcha. Another question that came in was, once we've entered into a prenuptial agreement, let's say something material changes and we want to update that. How do you handle that process?
That's a great point, because actually some clients have actually just called that. We did talk about amendment. I think it's in the slides. It says that you do your amendments in writing to a prenuptial agreement, and we refer to those commonly as a postnuptial agreement. That has become more commonplace as there have been changes in circumstances for people, and they will amend or update their prenup over time. And all the same provisions that you negotiated before the marriage can be renegotiated after the marriage or during the marriage in terms of the postnuptial agreement. And what you're trying to do there is the same intent. Rather than when we are in the heat of a moment where it can be more emotionally driven, where we're fighting, and I have now lawyers, and understand what your lawyers' roles are unless you direct them otherwise, is to be your advocate for the best position that you can get, highest settlement, etc. They are advocating with a purpose in mind, as opposed to amicably settling this relationship, dissolution of this relationship, which is what happens when you say, here's the postnuptial agreement to amend our prenup so that in the event that we do decide that we should get divorced, this is how we want things done. So that you've set up those rules so that, just like a fire drill, none of us want to actually have a fire in our building, but we've gone through fire drills and we get the fire drill instructions. Why? Because if it happens, we're much better off dealing with it in a calm, cool, collected, process-oriented way, as opposed to a panic-stricken way with that emergency.
All right, one last question, which is really focused on the education process and how far in advance do you start in the conversation about a prenup so that you avoid that question of duress.
Well, if they followed the recommendation that we've had in these slides, that you're talking about this conversation 6 to 12 months out before the wedding, then I think clearly you can say that the parties are going to be able to sign off on that agreement without a duress if you've actually started and signed. Sometimes people will sign as early as within, I think, 30 days is where people start to get really panicked about what are the provisions are going to be and are we far enough away from the wedding. And I think some of that just has to deal with the actual circumstance. But, you know, the earlier you can start, the better off you will be in having that conversation. And certainly where there are great extenuating circumstances, like there are policies that the family has, there's an expectation, the other family members have it, all of those things will come into play, which could be very favorable for entering into this process of having a prenup in place.
Great. Well, thank you, Domingo, for your insights and knowledge and sharing your input. If anybody would like the recording of this webinar to share with family or your fiance, a nice romantic dinner, and listening to this webinar on Wednesday would, I'm sure, be a great experience for everybody. Jennifer, any closing comments?
No, I think you did a nice job. Thank you so much, Domingo and Andrew, for sharing your information and perspective with us, and look forward to working with you guys again.
Excellent. Hope everybody can join us in La Jolla in a couple weeks. Feel free to email us with any questions. Thanks very much.
Great.
Thank you.
Bye-bye.